and I
Yeah.
can't represent you because I'm the judge.
Yeah.
You need to get some advice about the case that you're involved in from somebody that's an objective observer that can talk to you and give you the skinny.
Okay.
Because if I go forward today and make a decision, I'm going to throw your stuff out because you don't know what you're doing. Bottom line.
Okay.
You haven't done the paperwork properly. And the fact that you don't have an attorney doesn't mean that the counter plaintiff and defendant doesn't get to exercise his rights under the court rules and statute.
Sure, Your Honor. This is Hal Burke. I'm an attorney for Beaumont for the plaintiff.
Thank you. And Ms. Turner, can you hear us?
Yes.
All right. Good morning, ma'am.
Good morning.
So today's the date and time set for a pretrial. A pretrial is an opportunity for me to get some information from the parties, so I know a little bit more about what's going on with the case and hopefully put it on a calendar and move it towards a resolution.
Okay.
It looks like from your answer, Ms. Turner, and counsel, did you get a copy of that answer?
I did.
Okay.
Yes, I did.
All right. It looks like from your answer that you agree that the services were provided. You just think your insurance company should have taken care of it.
Right, and they did.
Okay. You got some documentation of that, ma'am?
Yes, I do.
Awesome. Have you shared that with plaintiff's counsel yet?
No.
All right, counsel, I'm going to suggest maybe we put you in a breakout room and see if maybe you can do a little exchange of information.
That would be great. And I always like to go in there unless she would just take my email, because if she emails me what she has, if she's willing to, I could maybe clear this up. If not today, sometime tomorrow.
Ms. Turner, can you email that to him?
Yes. I don't have a pen and paper just yet.
So why don't we put you in a breakout room and maybe you can take care of all that right now?
Okay,
Thank
that's
you.
fine.
Thank
All
you.
right. Thank you. Go ahead and Ms. Turner, go ahead and find an ink pen or something while we put you in a breakout.
Okay.
It's Dawn Giller versus Gurjeet Singh and Punjab
So you're here
Investments.
for Aaron Cox's office?
That's correct.
Okay. I'm going to put you back into the waiting room for just a few minutes and we'll pull you out in just a second, okay?
Very good. Thank you.
Judge, we do have Dawn Giller, and that attorney was on behalf of Aaron Cox. So as soon as,
Your Honor, I can tell you what we did. And
Please.
I tried to explain to her how to not leave the meeting, but just leave the breakout room. Either way, we did. Thank you. We did. She did get my email address. She kind of held up her
I'm
piece
here.
of paper. Oh, she said she's here.
She's back. Yep.
Okay. You can make it my request, whatever permission you would like. And that is, she's going to email me, I believe today, that proof that she believes this has been paid. And my request is if you'd give me a week or less, whatever you'd like, to verify the payment and maybe to continue moving on the case. If it's not the right information,
Sure.
maybe adjourning this and setting it for another final pretrial.
Yeah,
whatever you
what I'll do is I'll have the clerk set it for my next pretrial docket. If you two resolve it before then, that's great. If not, we'll have a pretrial next time.
I
Okay,
appreciate it.
thank
Thank
you.
you.
Ms. Turner, that makes sense? Any questions?
Yes. No.
Yes, it makes sense. No questions.
No. Right.
Okay. All right. My question was a bad one, so that's why your answer was confusing. All right. Good luck to you, Ms. Turner. Have a nice day.
Thank you. Have a great day.
Bye-bye. Bye.
we also have Mr.
Yep.
Groen and Akins back
Yep. Ms.
there.
Akins, you can hear me?
Yes, sir.
All right. Counsel, where are we at on this one?
Your Honor, I think we've come to an agreement. We just need some time to get the consent judgment over to Ms. Atkins, and hopefully that will take care of this matter. So if we can just adjourn this to your next pretrial date, I think hopefully.
How about
that
if we
should
just
be-
do this? I'll set it for an in-house review 30 days out with the idea we're going to have a settlement document before then. And if not, we'll set something else on the calendar.
We'll reset the pretrial at a later date then, if we don't
Yep.
get it. Perfect.
Ms. Akins, that work?
That works for me.
All right. Good luck to you.
Thank you. You guys have a
You're
wonderful
welcome.
day. God bless
You
Thank
as
you.
you.
well.
Thank you, Ms.
Yes.
Atkins.
Bye-bye.
Hey, Judge, we do have two other people in there for Mr. Groen. We have Don Snyder, who's scheduled at 9 o'clock.
Let's take care of the 9 o'clock Well, let's
He's
see.
got two of them scheduled at 9.
Who's he got at
He's
9?
got Citibank versus Snyder and LVNV versus Davis.
Is,
All right,
is Miss Davis on the line too?
She was.
Okay, because that might be quicker, because that one we've already come to an agreement. So if we,
It looks like she bugged out. Let me
did she? Okay, well, we can take care of her again in a little bit then.
Let's bring Miss Snyder in then.
Okay.
All right, Miss Davis, can you hear me?
Yes, I can.
All right. Good morning.
Good morning. How are you?
Excellent. Mr. Groen, your appearance for LVNV?
Good morning, once again, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of plaintiff LVNV Funding.
And you were saying before we had Miss Davis in that you think this case has been resolved?
It has been resolved. Miss Davis called her office yesterday and confirmed she can verify this if I'm misstating, but she verified that she did receive our consent judgment. And I believe
Yes.
she's going to be signing that and mailing it back to us. So if the court is willing to set another control date out, and hopefully we should be getting that consent judgment to you once we receive it back from Miss Davis.
Great. I'll do it the same way as the last file. Miss Davis, I'm going to set an in-house review for 30 days. Gives you plenty of time to get the documents exchanged between you and counsel and get it to the court. If something
Okay.
happens, we don't have that document within 30 days, then we're just going to schedule another pretrial and send out a computer notice.
Okay. No, I got
Make
it.
sense?
I can do that. Yes.
All right. Any questions, ma'am?
No, I do just want to ask if they did get my updated address. I just want to make sure because it's going to an old address.
Are
I
you
know
talking about a snail mail address or an email address?
Snail-
My
snail
snail
mail.
Okay.
mail.
Counsel, can you confirm that?
Let me pull up her file. I know another attorney took her call, so I just want to
Sure.
make sure he noted
Yep.
the address correctly. So let me put this in a second.
Miss Snyder will be with you in just a minute.
Okay. Thank you.
You're welcome. Have a good day, ma'am.
Thank you too. Take care. Bye.
All right. Counsel, your appearance on behalf of Citibank versus Snyder.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of plaintiff Citibank.
All right. Ms. Snyder, today's the date and time set for pretrial on this file. A pretrial gives me a chance to get some information from the parties about this particular file. Hopefully with the thought that we put it on the calendar and move it towards a resolution. Do you understand that?
Yes, sir.
All right, counsel, where are we at?
Your Honor, actually, we're in good shape with this one. Ms. Snyder has been making payments. The only thing is we sent her a proposed consent judgment a little over a month ago, and we have not received it back. So I just need to confirm, did you ever receive the consent judgment from our office, Ms. Snyder?
I did, sir. The reason I didn't send it back was because I talked with the lady from your office many months ago, like last year sometime, maybe around September. And I told her I wanted to make arrangements to start paying on it. And she said, okay. She said that if I paid $75, that I wouldn't have a judgment. And I told her that, I pay almost $600 a month in student loans. And right now, the only reason I've been able to pay $75 every 2 weeks to you is because my student loans are in deferment. And I asked for her to
Turn it off.
to lower it to 50. And she said she couldn't do that. So since you guys went ahead and did a judgment anyway, I was going to ask the court if I could lower that to $50 every 2 weeks, because once the student loan deferment ends in September when it's due, I'm going to be back up against the wall I know it seems like it's only $25 every 2 weeks, but that's how I pay my student loan. Is
How
every 2
about,
weeks.
if I tell you what, I can revise the consent judgment and do the $50 biweekly payments. And how about you, we can't change it that quickly. How about as of maybe like a month from now, it can switch to the $50 payments? Would that work if I put in that?
I can continue to pay the 75 until our student loans go back in deferment.
Tell you what,
till
yeah.
the national deferment is over.
Tell you what, I'll just put the $50 amount biweekly to begin in the month. If you want to keep making the $75, it's going to keep, your judgment's going to go lower by that much more each month that you can pay more.
Right.
But at any point that you need to reduce it back to that 50, then you should be good to go from that point forward.
Okay.
Are you still,
I'm agreeable to that.
are you still at the 9463 Barry Drive address then in Romulus?
Yes, sir.
Okay, so what I'll do is
Yes, sir.
I'll revise the consent judgment to do those new terms that we just discussed. And I will get that out to you hopefully by the end of the week.
Okay.
Okay?
Okay.
All right, so what we'll do is we'll set it for an in-house review 30 days out, gives you you two a chance to exchange the information and get it to the court. If we don't have that final document within 30 days, Ms. Snyder, the computer will kick out another notice for a pretrial, just like the one that was scheduled for today.
Yes, sir.
All right? Any
Yes, sir.
questions?
No, sir.
Good luck to you. Counsel, thank you.
Bye-bye.
I have one more, Your Honor.
Oh, I thought that was for me. Okay, have a
No,
good one.
you're all
Bye-bye.
set. Thank you, Ms. Snyder.
Ms. Dumas has not checked in yet. So I'm going to put you back in the waiting room for a few until she does, okay?
I'll stay. It's not even time yet, so that's perfect. Thank you so much.
All
Thank
right.
you, sir.
Paula, give me a second. I want to talk to Ms. Porter real quick, and then we'll bring in the Giller party.
Thank you.
Ms. Porter, I got you muted. Can you unmute?
Yes, sir.
There you are. Good morning. How are you today?
Good morning, Judge Opie.
All right, so you're a little bit early. I just wanted to let you know that I saw you in the waiting room. We got you connected. I'm going to kick you back in the waiting room, see if anybody shows up at 9:30. All right?
Okay, sir. All righty.
We'll see you soon.
Okay.
The other two are on their way in.
Thank you. All right, looks like Ms. Giller is connected. Counsel, your appearance for
Good morning,
the
Your Honor.
defendant.
Good morning, Your Honor. Brian Gerda, P 8056, on behalf of the defendant's counter plaintiffs.
All right. So, counsel, what do we got scheduled today?
This is our motion for summary disposition, C8, C9, and C10.
Right, okay. Yeah, I looked at this last week. Ms. Giller, did you get a copy of that paperwork that was filed with the court by the counter plaintiff defendant?
Yes.
All right, just confirming, did you submit a written request? Or excuse me,
Yes.
a written response?
Yes, I did.
Okay, that's that really big stack of documents with no explanation to it? Correct?
Yes, I'm sorry. Yes,
Okay.
that's correct.
All right, well, that puts me in a really awkward situation because I've got over an inch thick stack of documents. I'm not gonna go through this stack of documents, try to figure out what I think they mean to you.
Okay.
So, you know, when you file a written response to a motion, usually you explain your argument, you explain what each one of your exhibits means, so on and so forth.
That's okay.
So I'm inclined to give you two options. Number one, you can try to do that orally today, or number two, I'll give you another date so you can submit more paperwork that explains what all these documents are supposed to mean to me.
It's very simple. I just wanted to show pictures.
Okay?
Basically, from the beginning, the first exhibit is the advertised Cordell house. When I originally looked at the house, you can see the damage. I zoomed in on where in the kitchen the damage was coming from. I had a water leak that was coming down from the kitchen. And you can clearly see it. He was talking about new appliances. I have pictures to show in there that there was not. The piping, I had an open sewage line, 2 of them that were not capped in the kitchen. I had, I paid for things he was supposed to pay for. I paid for 3 trees to be removed in the back of the house.
Okay, let me interrupt you just for a minute, because I think what you're doing is telling me about all the support you have for your case against the defendants.
Yeah.
Okay, that's not what we're discussing today. What's scheduled for today is the motion that's been filed on behalf of Punjab Investments and Mr. Singh for summary disposition, which basically says your case against them should be dismissed Did you understand? Did you read the motion?
Yeah, so I thought that's what I was doing. I submitted the pictures, the city
Okay.
documentation showing his default.
Well, all right, let's start with, I think, what I think will be the low hanging fruit. One of the things, and counsel, if I misspeak about your position, would you please correct me?
Yes, Your Honor.
One of the low hanging fruit out of that motion, I think, is that Mr. Singh individually should not be part of this lawsuit because you did not do business with Mr. Singh. Counsel, is that a fair summary?
Yes, Your Honor.
Okay, so let's talk about that first, Ms. Giller. Why should Mr. Singh be sued individually if you did business only with Punjab Investments?
I put both names because he was the primary person that I was going through. So I
Okay.
put both names. I put Punjab Investments as well as Guri.
Okay, but would you agree with me that if you go to buy a GM car from a dealership and the car is faulty and you sue GM, you don't sue a GM shareholder just because they happen to own some stock?
Right. Well, I did add his company name onto Punjab Investments is listed on the documents.
No, and I understand that you did business with Punjab Investments, which is a separate legal entity from Mr. Singh. Would you agree with me there?
Well, he's the owner of it, right?
Well, he may be, but that doesn't make him the same as the company.
Okay, so they're two separate.
They're two separate legal entities.
Okay, so by me putting both names on the case, though, it still holds him liable for his company, right?
That's what we're trying to determine today. Why should he be
Yeah.
liable if you did business with his company and he was just a representative of the company?
I want to be able to hold him accountable. I mean,
Okay,
he
but you
has.
have to give me a legal reason why he is accountable. If you sue Kroger because you went to buy groceries and you fell and hurt yourself and you dealt with a cashier, would you sue the cashier because she worked for Kroger?
No.
Okay, that's the same situation here from a legal standpoint, unless you've got some reason why Mr. Singh is individually liable when, from what I've seen, all he did was represent Punjab Investments in the company's dealings with you. Follow me?
Yeah, I do.
I'm not saying that the company might not be liable to you,
Right.
but at this point, I want to talk about the attorney's argument that Mr. Singh individually is not liable.
Okay, he was the individual that I was personally dealing with. I put both because I want him to be able to be held accountable. If it's
Okay,
the
ma'am,
case,
what you want is not real important to the discussion today. Is there a legal reason that he do something wrong individually that makes him individually be liable? Or did he just represent Punjab Investments when you dealt with the company?
he was representing his company.
Okay. All right, is there any other reason you thought you should put his name on the paperwork?
I put it on because he was the main person that I was dealing with.
Okay,
I mean, the legal.
so he was your
stand-
contact.
Yes,
I understand that. Okay, but that alone does not make him individually liable for any damages you suffer from Punjab Investments. Understood?
correct.
Okay, all right. So counsel, as to Mr. Singh, the motion's granted, he's out.
Thank you, Your Honor.
All right, so counsel, go pick up from there and hit the high points of the balance of your motion.
Yes, thank you, Your Honor. I just want to highlight a couple troubling procedural deficiencies from the plaintiff's case here. No response has been received at our office to this motion for summary disposition that we filed. We are working with a small claims complaint in this case that's very vague, ambiguous, doesn't really state any cause of action. In fact, the only things listed on there are items that were caused by Ms. Giller herself while she occupied the property and didn't report any deficiencies in the condition to the landlord, Punjab Investments. All that said, we just don't have much in the way of pleadings to respond to, but I hope our motion brings everything to light into what's really going on here. This is a case brought with vexatious intent, vindictive intent, because my client issued a notice to quit and proceeded with summary proceeding action to evict Ms. Giller. And on our Exhibit 3, we attached a demand for possession. And the explanation there was failing to report a leak in a timely fashion, causing extensive damage to kitchen, mold, destruction of property. And this is a common theme here. Ms. Giller resided at the property, she leased it, and would not report or make maintenance requests for things that need to be done, such as this leak that occurred in a timely fashion.
Sorry to interrupt, but how long was she in residence?
She, let's see, began on September 7, 2018. We've gone through August 2019. I don't have any extensions in my file, so I imagine she was month to month after that. And then the notice to quit was sent at October 23, 2019.
So October 23 is when you sent the notice, and she moved in when?
She would have moved in on or around September 7, 2018.
All right, so roughly a year plus. Okay, go ahead.
Correct. So with her failure to report that, we've also attached, as a landlord takes back possession of their property, or landowner, they're able to finally go in and inspect and see what the tenant did. And we attached a list, and there was Exhibit 4 to our motion for summary disposition. As to the exorbitant amount of damages my client had to incur in completely fixing all the wreckage that Ms. Giller left behind. We don't know why all this happened. Could have been mere negligence, could have just been a lack of care for another individual's property, but the reasoning is ultimately irrelevant. The fact is that all this damage was done when my client gave her the property without all this damage at the start of their lease. And none of this is what we call normal wear and tear. A tenant is excused from being charged for anything that is considered normal wear and tear. And all this is absolutely excessive and abnormal, uncommon sort of damage that property owner finds in their property. The bill there is $15,225 to repair what had to be done. Additionally, in addition, she did not pay 2 months of rent, and that's sitting out on her ledger, so we're also seeking that amount. So any of the claims, it's two ways, we got counterclaims here. So any of the claims brought by the plaintiff, she's not able to justify or point to any legal cause of action. As I mentioned, she's simply citing to things that she did at the property. You can't tear down a wall, wait a year, and then blame the landlord for you not having a wall. If it's something that happens in the ordinary course of living somewhere, you need to report it. You need to make a maintenance request. If there is something such as a leak, you need to report it to a landlord. Failure to do so that causes damage to the property is the fault of the tenant. And just like the other damages that we have here. So in summation, she hasn't stated a legally cognizable claim. And there's no evidence provided either in response to our motion or attached to a complaint or an amended complaint for us to work with here to even see what, if anything, supports her allegations. On the flip side, we have documentary support in support of our claims for damages in response, and Ms. Giller has not provided anything to refute that. So I am requesting that this time, and this motion has been scheduled for months now, that the court dismiss her complaint in its entirety as to the remaining defendants, the LLC, and award judgment in favor of Punjab to recover from the damages sustained of Ms. Giller's tenancy.
All right. The last time I saw parties on this matter was back in May of, man, my date stamp was bad. It looks like May of last year. And we discussed the fact that the parties were going to go to Wayne County Neighborhood Dispute Resolution. Did that happen?
No,
Why not?
I never heard anything. I waited to hear something back from them.
I
Counsel,
believe
do
there's
you
a
know?
lot more to that story.
Well, I'm giving you a chance to tell me.
Yep, I didn't want to interrupt her. So Mr. Horka from our office, and I believe there was one appearance in between May, because I was here back in May, where it was said that she hadn't received a copy of our motion for summary disposition.
Yeah, you know what?
At that hearing, I remember.
It looks like we were briefly on the record November 24th.
Right.
And just talked about renoticing the motion. So what happened with the
And so-
mediation idea?
I remember speaking with Mr. Horka to get a status update from that date. And he said that the tribunal, I don't remember the exact name, had never heard back from Ms. Giller, had left her multiple messages and maybe even sent an email, if my memory serves me correctly, that she was simply not responding at all to coordinate mediation. And I thought that was addressed at the November hearing where it was the decision of the court. Okay, fine, we will schedule this motion.
And that might have been, my notes might just be deficient on that. Does that sound right, Ms. Giller? Does that sound right that we talked about mediation in November and just decided to go forward with the motion?
Yeah.
Okay.
I never heard back from the mediation people. I'm not exactly sure what happened or what he's even talking about because I was never contacted.
All right. So are you willing to go to mediation?
I want to completely be done with this case. I have a lot of stuff all the way down to city documentation. That house was never even registered for somebody to be living in it for the first year that I was there.
Okay, but ma'am, that doesn't answer my question. So we're not going to be done with this case today. So my question is, are you willing to go sit down with a mediator to see if a mediator can help you and Mr. Singh on behalf of Punjab Investments work something out between you to settle this case?
Sure.
All right, so here's what I'm going to do. Counsel, I'm going to order her to amend her complaint within 3 weeks. I don't think there was ever a motion for a more definitive statement. So I'm going to order her to give a amended complaint, file it with the court, that hopefully gives you folks a cause of action so you know exactly what you're defending. If it's still deficient at that point and that item or that issue still fits into your motion for summary disposition, then we'll deal with that at a scheduled notice for the motion. In the meantime, I'll leave it to the parties to contact Wayne County Neighborhood Dispute Resolution and get something set up.
I've just never had to do that before. So this is basically like just the a mediator that's going to sit between the two of us.
It's a mediator because, ma'am, you don't have an attorney involved and I can't represent you because I'm the judge.
Yeah.
You need to get some advice about the case that you're involved in from somebody that's an objective observer that can talk to you and give you the skinny.
Okay.
Because if I go forward today and make a decision, I'm going to throw your stuff out because you don't know what you're doing. Bottom line.
Okay. Okay.
You haven't done the paperwork properly. And the fact that you don't have an attorney doesn't mean that the counter plaintiff and defendant doesn't get to exercise his rights under the court rules and statutes.
Right. Okay.
So, either I got to start taking over your case, which I can't do,
Yeah.
or you're going to lose because you don't have a clue what you're doing.
Okay.
Now, I don't know if your case has merit or not. I just know that the paperwork that's been submitted to the court doesn't show much for me to work with if I want to find in your favor.
Okay,
Am I making sense?
yeah,
So if I send you to a mediator, the mediator is going to talk to both sides about their strengths and weaknesses and
okay,
try to help you to resolve the matter. If you can't resolve it, that's fine. Then you're back to court for me to make a decision. But if I had to make a decision today, you're in trouble.
okay.
So A, I think the mediator might assist in that, and B, that'll give you some time to try to get the advice of an attorney. So if we do move forward, you at least have the proper paperwork that's been filed in the proper manner.
Okay,
So are we clear on a cause of action or a course of action, counsel?
Yes,
I'm
Your
gonna-
Honor. Can we get can we establish some 100% accurate contact information for the defense today? Because I will set up the dispute resolution and I want it said exactly how she will be contacted.
Sure. Ms. Giller,
So I
I've got
think
your
I
phone
require
number.
an email.
Yeah, let's start with a phone number. I got you down with 313-932-7286.
yes.
All right. How about an email? Do you use an email?
Yeah, it's Dawn, DAWN, the letter N, Giller, GILLER, at yahoo.com.
So it's Dawn with an extra N, Giller.
Yes, yes.
Counsel, did you get that?
I did, but I did not get the phone number. 313-9.
932-7286. So counsel, what I noted in my file that Singh removed from the suit as a result of your motion. The balance of the motion is going to be adjourned to a later date yet to be determined. In the meantime, Ms. Giller's got 3 weeks to file an amended complaint, and the parties are going to set up mediation.
What kind of timeline would you like for us, Your Honor, to get that mediation done?
I have
I think
no
with the
idea how
dispute
to-
resolution center,
Yeah, I have no idea how they're
Last
scheduling
time-
right now.
last time it took me a good 90 days from the date of scheduling because they kept having to kick it back. So
Let's do this
nothing
then.
short.
I'll set this up for an in-house review, 90 days, so it just doesn't fall through the cracks, with the idea that hopefully we'll hear from you or Ms. Giller between now and then.
All right, and Ms. Giller will receive an email that from no reply at courtinnovations.com, and it'll be subject a message from the Wayne County Dispute Resolution Center. She will be required to go in there and accept the mediation after I create the case in there. And then we will wait, no one knows how much time, and they will assign a mediator who will reach out via email to the parties to pick a date that's mutually agreeable. So that email, check spam folders, whatever, that's where it's coming from.
Okay,
All right, we got that, Ms. Giller?
yes,
All right, good luck. Counsel, thank you.
thank you.
All right, thank you, Your Honor. Have a good day.
You as well.
Has
Paula,
that
do we
been-
have an attorney on Midland Credit for Midland versus Parton?
I believe that is Mr. Nager. I was just going to say, I'm going to bring him in and verify that.
Go ahead.
And then next, if you don't mind, I'll bring in Michael Beach. I believe he is an attorney as well. Good morning, Mr. Nager. Are you here for Reese Parton,
Yes.
Midland? Okay, let me bring her in.
Got her, Paula. All right, counsel, your appearance for Midland Credit versus Parton.
Good morning. Omar Nager, P 58066 on behalf of the plaintiff.
All right, Ms. Parton, you can hear me?
Yes.
Thank you. All right, today's the date and time set for a pretrial, I believe.
I believe that's correct.
Ms. Parton, a pretrial gives me an opportunity to get some information from you folks so I know a little bit more about what's going on with the file, with the plan of putting it on our calendar and move it towards a resolution. So Mr. Nager, where are we at from Midland standpoint? We need some discovery. We're ready for a motion. Where are we at?
I think we asked for some discovery time if we can't resolve it right now. I don't know. I saw her answer. It says, I guess she doesn't know who we are or something. We're just a debt buying company. We bought the debt.
All right, so probably makes sense just to adjourn the pretrial until after at least 60 days with written discovery.
Yeah, I think so.
All right. Ms. Parton, discovery just means an exchange of information. So Mr. Nager is probably going to send you a list of questions he wants you to answer. He might say, if you've got a copy of such and such document, we want to see it. You can do the same thing. If there's any information you need from Midland to help you prepare your claim or your defense of their claim, then you can request those things from Mr. Nager. You understand that?
Yes.
All right. We'll send out another computer generated notice for a pretrial that'll be at least 2 months from now to give you two a chance to exchange that information. Do you have any questions?
No.
Mr. Nager, anything else?
No, Your Honor.
All right, Ms. Parton, while I've got you on, why don't you give me your phone number so I can put it in the court file?
734-772-4519.
Yes, ma'am. Yes, ma'am. Thank you. All right, you two have a nice day.
Can I just ask Ms. Parton if it's all right if I call her later just to see if we can discuss the case?
Yes.
Awesome.
You might get a call if you block call, but I'll leave a message if you have a voicemail and you can come, I'll leave you my number too.
Okay.
All right, sounds good.
Good luck.
Thank you.
Judge, I do have Mr. Katz in for Ursula Porter. Do you want them in next?
I don't know why he keeps doing that. Sure.
Okay.
All right, good morning again, Ms. Porter.
Good morning.
All right, Mr. Katz, are you representing someone on this file?
Your Honor, as I think we discussed last time that I'm not, but yet I'm still listed on the case and I got notice to appear on this case. Because I don't think she ever modified who the plaintiff is, and I have no idea who two individuals are that she's listed on the complaint.
Well, today what we've got up is a request for default judgment against Barrington Apartments LLC.
Correct. No such entity exists, Your Honor.
Okay. All right. So, Ms. Porter, you understand what's up today?
Yes, I put down Stacy Gilmore and Gordon Lambert too.
Okay, but that's not the judgment that's been entered or you're seeking to enter.
Okay.
Did you, I don't know where this judgment came from. I'm assuming you prepared it?
Yes.
Okay, but the only name on it under defendant is Barrington Apartments LLC. You understand that?
Yes, sir.
All right, and the reason we scheduled the hearing is because on that judgment, you're asking for attorney fees of $1,925. And I don't know how you're asking for attorney fees because you've never had an attorney on this file.
And she sent me the paperwork and I changed it up. You sent me, told me to send in the original people names, Stacy Gilmore and Gordon Lambert. That was on the first one. Cause they said, I remember he said they have no identity of the Barrington's apartment. And so I entered Stacy Gilmore and Gordon Lambert. And
Okay,
they didn't appear in court.
I don't have a judgment with their name on it that's been submitted for signature. The only judgment that's been submitted to the court is the one for Barrington Apartments LLC that requests attorney fees. So if you want a judgment with individual names on it, you've got to submit that judgment and then we can deal with that one.
Okay, that's what I'll do.
But the only one I've got in front of me, and the reason I set it for a hearing was because it's asking for attorney fees, and I know you never had an attorney represent you on this file.
I'm my own attorney.
Right.
Yes, sir.
Right.
Yes.
And as such, you can't ask for attorney fees because there's no attorney. You follow me?
Yes,
Okay.
I do, sir.
All right. So I think we're in agreement that nothing's going to happen on this piece of paper. You're going to file another judgment.
Yes, sir.
Okay. And Mr. Katz, do you want us to remove you from the register of action on this file so you no longer get notices?
As it relates to the parties listed, yeah, I think I could be taken off of it, Your Honor.
Yeah, the only parties listed, I'm looking at my ROA, is plaintiff, obviously, and 3 defendants. Barrington Apartment LLC, Stacy Gilmore, and Lambert Barrington Apartment. Those are the three defendants we've got listed.
And I don't know who any of those are yet. Miss Porter needs
Stacy,
personal
Stacy
service.
Gilmore
Hold on, Miss
works in
Porter.
your office.
Hold on, Miss Porter. Go ahead,
She
Miss
needs
Cat.
personal service on those, on any of those individuals as well, which I don't think has been established since I don't even know who those people are.
Okay, well, I don't know why you would know about anything on those if you haven't filed an appearance and gotten any documents on them.
Correct, but I do get copies on them, Your Honor.
Okay.
And I
Alright.
think we've already established that in previous, that there was never any personal service on any of these individuals since.
Yes, it was. Yes, it was. I delivered it to Stacy Gilmore. She's the manager at your office, and I gave her a certified letter to her face for her to appear in court. I delivered it myself.
So my question, Mr. Katz, is we keep getting you involved, but it sounds like you're not involved. You shouldn't be. So,
Under the scenario right now, I don't think I need to be involved.
so I'm going to make a note for the clerks to remove you from the notice stream.
Okay. All right.
And I'm also making a note for Ms. Porter. I'm making a note in the file that the default that's been submitted against Barrington Apartments LLC, you don't want to move forward on that one. You're going to submit another one.
Yes.
Agreed?
Yes.
Okay.
Okay.
Thank
All
you.
right.
Your
Have
Honor.
a good day.
Thank you.
Thank you, Judge Oakley. Have a
You're
blessed
welcome,
day.
ma'am. You as well.
I'm going to find out who Michael Beach is.
Yeah, go ahead.
Good morning, Mr. Beach. Can you tell me what case or cases that you are here on?
Yeah, I've got CACH versus WA, KWAW.
That was scheduled at 9 o'clock and the other party has not checked in yet, Judge, that I'm aware of. I don't see anybody over in the waiting room.
All right, I'm sorry, Paul. I was writing notes. When was that one scheduled?
It's scheduled at 9 o'clock, Cash LLC versus Quad, KWAW. I don't see anybody that's checked in with that name. We have one that's unidentified and that's it.
Let's check on the unidentified before I do something.
Okay, hang on just a minute, Mr. Beach.
Counsel, it looks like the last time we were on this file was January and there was going to be an amended police report by the defendant.
That's correct, Your Honor.
Okay. Do you ever, you know if that happened? Did you get a copy of it or anything?
We didn't get one to the court. Did you submit anything to the court?
No.
Your Honor, to be totally honest, I was just looking at the notice this morning, and if you look at the notice, the address it was sent to for the defendant, it's not the address that he put on his objection.
Looks like it went to the Schrock address.
Yeah, and on his objection, he had it at a West.
Crest.
So I don't know. Did the court at the last hearing, did they give us a new date? I don't know.
Yeah, on January 19th, we set this date.
Okay, so he had at least had oral notice of it.
Yeah.
Judge,
Sandy, are you listening?
Yes, Judge. Yes.
Counsel, I think we better reschedule this.
Yeah, I tend to agree with you, Judge. It's just to be I'm all for fairness, but you know.
Yeah, I mean, I'd like to not see it drag on, but given the fact that he sent something in with address A and we're still using address B.
Yeah, I totally get it. But I just wish he would have followed through on what he was supposed to do.
Yeah.
Judge, Galaxy Note 9 is not responding to my chats.
Okay.
Doesn't even look like they're trying to connect. I'm going to go ahead and remove them and make them call back in. So,
Yep.
okay. Okay. Are you finished with Mr. Beach or?
This courtroom moment starts with a clear warning. Follow the rules or face the consequences. The judge walks in and immediately sets the tone. Stand when your name is called. be present. Because if you're not, a warrant can be issued. Just like that. No excuses, no second chances in that moment. And as the cases begin, that same message keeps showing up again and again. One defendant stands there after violating probation, not just missing steps, but committing a new offense while already under supervision. Even after treatment programs and multiple chances, the pattern didn't change. And that's when the judge made the decision, revoking probation and sending him to prison. Not out of anger, but because the system had already given him opportunities he didn't take. Then another case flips the situation completely. A man sits in jail for over 100 days without proper indictment. No money, no support, waiting. And this time, the judge steps in differently, granting a personal bond, giving him a chance to fight his case outside custody. Because fairness in court goes both ways. Because at the end of the day, the courtroom isn't just about punishment. It's about decisions. By the court and by the people standing in it. So here's the real question. Should the system focus more on giving chances or on acting strictly the moment someone breaks the rules? Like and subscribe for more real courtroom moments.